Lawyer Radio Podcast with attorney Brian Figueroa of the law firm Figueroa and Associates. This podcast features a recording of our most recent radio show. We hope you enjoy the show, which features news, views, and interviews on matters such as immigration, personal injury, bankruptcy, divorce, family law, estate planning, wills and probate, deed transfers, civil rights, criminal defense, workers' compensation, and taxes, both individual and business. You can contact us at 855-768-8845 or visit us at www.askthelawyer.us. You have questions? We've got the answers.
For many artists, bands, and musicians worldwide, performing in the United States represents a significant opportunity to expand their careers and connect with a global audience. The U.S. entertainment industry is one of the most vibrant and diverse markets, offering international performers the chance to reach new fans, collaborate with American talent, and experience the rich cultural landscape of the country. However, to legally perform in the U.S., artists, musicians, and entertainers must obtain the proper visa, usually under the P visa category. In this comprehensive guide, we will analyze the process for an artist, band, or musician living overseas to successfully apply for an entertainer visa, specifically the P1, P2, and P3 visas. We'll cover the eligibility requirements, application procedures, the role of the U.S. consulate in the process, and practical advice for navigating the complexities of U.S. immigration law for performers. Understanding U.S. entertainment visas, P1, P2, and P3. The P visa category is designated for internationally recognized performers, artists, and entertainers who want to come to the U.S. to participate in a specific event, tour, or performance. Unlike the O1 visa, which is for individuals with extraordinary abilities, the P visas are tailored for those who are part of a group or collaborative effort and may not necessarily need to meet the same stringent requirements. Here's a breakdown of the three main types of P visas. P1 visa, internationally recognized performers. The P1 visa is for artists, bands, and entertainers who are part of a group that is internationally recognized. It allows foreign nationals to come to the U.S. to perform in an internationally recognized entertainment group, participate in an event, or compete in a cultural or sporting event. Eligibility. To qualify for a P1 visa, the group or individual must have an internationally recognized reputation in their field. This means that the group or act should have achieved recognition beyond their home country and be well known in multiple countries. Duration. The P1 visa is granted for the duration of the performance or event, typically not exceeding 1 year. Extensions are available in 1-year increments as long as the performer remains engaged in the same event or tour. P2 visa, reciprocal exchange program. The P2 visa is for artists or entertainers who are participating in a reciprocal exchange program between an organization in the U.S. and one in another country. This visa is designed to facilitate cultural exchange through performances, workshops, or collaborative artistic endeavors. Eligibility. Applicants must be part of a reciprocal exchange program recognized by the U.S. government. The exchange program must involve artists of similar talent and background in both countries, ensuring equal opportunities for both American and foreign participants. Duration. The visa is granted for the length of the exchange program or event, not exceeding 1 year, but extensions are possible under certain conditions. P3 visa, culturally unique artists. The P3 visa is for performers or entertainers who are coming to the U.S. to participate in a culturally unique program. This visa allows artists to present, teach, or coach performances that highlight cultural traditions, ethnic expressions, or folklore unique to their home country. Eligibility. The applicant must prove that their performance is culturally unique and that they will participate in an event, program, or workshop that highlights or promotes their cultural heritage. Duration. The P3 visa is granted for up to 1 year, with the option to apply for extensions. Each of these visa categories has specific requirements and procedures, but they all share the common goal of allowing foreign artists, entertainers, and performers to legally work and perform in the U.S. Step-by-step process for applying for an entertainer visa. Step 1. Secure a U.S.-based sponsor or employer. The first step in obtaining a P visa is securing a U.S.-based sponsor or employer. Unlike tourist visas, which are self-petitioned, a P visa requires a petition from a U.S. organization, agent, or employer. This could be a concert promoter, music festival organizer, cultural institution, or a venue hosting the performance. Who can be a sponsor? The sponsor must be a U.S. entity or individual who has the authority to petition on behalf of the artist or group. The sponsor is responsible for submitting the visa petition and must show evidence that they are hiring the foreign performer for a legitimate event, tour, or project in the U.S. Step 2. File Form I-129, Petition for an Immigrant Worker. Once a sponsor or employer is identified, they must file Form I-129, Petition for an Immigrant Worker with the U.S. Citizenship and Immigration Services, USCIS. The I-129 form is the primary application that sets the process in motion and must be completed by the U.S. petitioner. Supporting documents. Along with Form I-129, the petitioner must submit supporting documentation that includes a detailed explanation of the event or performance schedule, contracts or letters of intent outlining the terms of the engagement, proof of the artist's or group's eligibility, e.g. international recognition for P1, evidence of a reciprocal exchange for P2, or proof of cultural uniqueness for P3, documentation of previous international performances or tours for P1. Filing fee. As of 2024, the filing fee for Form I-129 is $460, though it's essential to check the latest USCIS fees. Step 3. Wait for USCIS approval. Once Form I-129 is submitted, USCIS will review the petition to ensure it meets all the requirements for the specific P visa category. Processing times for USCIS can range from several weeks to several months. However, for those needing faster processing, premium processing is available for an additional fee, which expedites the decision within 15 calendar days. Approval notice. If USCIS approves the petition, they will issue a notice of approval, Form I-797, which is necessary for the next step, applying for a visa at a U.S. consulate. Step 4. Apply for a visa at the U.S. consulate. Consular processing. Once USCIS approves the petition, the artist, band, or musician must apply for their visa at the U.S. consulate in their home country. This step involves several important tasks. Complete Form DS-160. All visa applicants must fill out Form DS-160, the online non-immigrant visa application. This form collects personal and background information about the applicant, including details about previous travel, employment history, and intended activities in the U.S. Schedule a visa interview. The applicant must schedule an interview at the U.S. consulate or embassy in their home country. The wait time for interview appointments varies depending on the location, so it's important to book the appointment as early as possible. Documents to bring to the interview. Passport. Valid for at least 6 months beyond the intended stay in the U.S. Visa application fee payment receipt. As of 2024, the fee is $190 for P visas. Form I-797, Notice of Approval, from USCIS. Confirmation page of Form DS-160. A passport-sized photo that meets U.S. visa requirements. Any additional documentation that supports the purpose of the trip, e.g. contracts, event details, or a letter from the sponsor. Visa interview. During the visa interview, a consular officer will ask questions to determine the purpose of the visit, the duration of the stay, and the artist's ties to their home country. The officer will also verify the details provided in the visa application and the I-129 petition. If the interview is successful, the visa will be approved. Step 5. Enter the U.S. and begin performing. Once the visa is approved, the applicant will receive their visa stamp in their passport. The visa allows them to enter the U.S. for the specified duration of their performance, tour, or event. Upon arriving at a U.S. port of entry, they will be inspected by a Customs and Border Protection (CBP) officer who will issue an I-94 arrival departure record that specifies how long the artist can remain in the U.S. Special considerations for artists, bands, and musicians. Multiple members of a group. For bands and performing groups, the P1 visa can cover all members of the group if they meet the criteria for international recognition. However, each member must be part of the group for at least 1 year before the application, except in cases of illness or other emergencies that necessitate temporary replacements. Essential support personnel. In addition to the main performers, essential support personnel, such as sound engineers, makeup artists, or production crew, can also apply for P visas under the P1S, P2S, or P3S categories. These visas are for individuals who are integral to the success of the performance and who have critical skills that cannot be easily replaced by a U.S. worker. Traveling on multiple performances or tours. Artists, musicians, or bands playing multiple performances or tours in the U.S. can apply for P visas that cover the entire duration of their tour schedule. If the performance schedule changes, the sponsor or agent must notify USCIS and, if necessary, file an amendment to the original I-129 petition. Dual intent and future immigration options. While the P visa is an immigrant visa, it allows for dual intent, meaning the artist can apply for permanent residency, green card, later if they meet eligibility requirements. This is particularly important for artists who may wish to pursue a more permanent career in the U.S. The U.S. offers a vibrant and diverse landscape for artists, bands, and musicians from all over the world to showcase their talents and contribute to the cultural richness of the country. However, to legally perform in the U.S., foreign artists must navigate the complexities of U.S. immigration law, specifically by applying for the appropriate P visa category. The process of applying for a P visa involves securing a U.S.-based sponsor, filing Form I-129 with USCIS, and attending an interview at the U.S. consulate in the applicant's home country. While the process can be complex, careful preparation and attention to the specific requirements of each visa category can help ensure a successful application. For artists looking to pursue multiple performances, tours, or cultural exchanges, the P visa offers a flexible and reliable pathway to performing in the U.S. The law firm of Figueroa and Associates, which has over 25 years practicing immigration law, can help you navigate the process and avoid common pitfalls. To schedule an appointment, visit www.askthelawyer.us or call 855-768-8845. The lawyer you hire does make a difference.
Do you have a legal issue, question, or concern? Turn to Ask the Lawyer. You have questions? We've got answers. For a consultation or to refer a client, visit www.askthelawyer.us. Again, www.askthelawyer.us. You can also register for our paralegal program, get legal news, business consults, or other information on educational issues. Yes, Ask the Lawyer. You have questions? We've got answers. For a consultation or to refer a client, visit www.askthelawyer.us. Again, www.askthelawyer.us.